Law of Contract, viva semester first LLB 3 year. Law of Contract, long answer question. All contracts are agreements, but all agreements are not contract. Answer: that's a classical principle from contract law, and it's absolutely correct. Let's see it clearly. Statement: all contracts are agreement, but all agreements are not contract. Meaning, every contract starts as agreement, but not every agreement qualifies to become a contract under the law. Step by step, we see the explanation. Agreement. An agreement is simply a promise or a set of promises forming consideration for each other. Formula: agreement is equal to offer plus acceptance. Example: A says to B, I will sell you my car for rupees 2 lakh. B says, I agree. There is an agreement. To contract. A contract is legally enforceable agreement. That means it can be enforced in a court of law. Formula: contract is equal to agreement plus legal enforceability. Example: A agrees sell to his car to B at rupees 2 lakh. They both sign a proper sales contract. This is a contract because it is legally binding. Why all agreements are not contract? Not every agreement has legal enforceability. Some agreements are social or moral in nature, not recognized by law. Example: B invites to A to dinner. A invites to B to dinner, then B is accepts. If B doesn't show up, A cannot sue him. It's a social agreement, not a contract. Legal reference: Indian Contract Act 1872. Section 2E. Every promise and every set of promises forming the consideration for each other is an agreement. Section 2H. Agreement enforceable by law of contract. In short, concept, definition, legally enforceable. Example. Concept: agreement, definition, offer plus acceptance, legal enforceability, not always, and example is promise to meet a friend. Contract, agreement plus legal obligation, legally enforceable, yes, and example is employment agreement. Write a short note on person of sound mind. Short note on person of sound mind. According to Section 12 of the Indian Contract Act 1872, a person is said to be of sound mind for the purpose of making a contract if at the time of making it he is capable of understanding it and forming a rational judgment as to its effect upon his interests. A person who is usually of sound mind but occasionally of unsound mind may make a contract when he is of sound mind. Conversely, a person who is usually of unsound mind but occasionally of sound mind can only make a contract during those interval of sanity. Example: person suffering from the mental illness cannot make a valid contract while his mind is unsound. A drunk or intoxicated person cannot contract when he is incapable of understanding the nature of the agreement. Thus, soundness of mind of the time of contract is essential to ensure that consent is free and valid under the law.
Paper number 2, special contract, semester first year. Viva question. Define indemnity. What are the essential contract of indemnity? How it differ from the contract of guarantee? Definition of contract of indemnity. Section 124 of the Indian Contract Act 1872 defines a contract of indemnity as a contract by which one party promises to save the other from loss caused to him by the conduct of promiser himself or by the conduct of any other person. In simple word, a contract of indemnity is an agreement in which one party promises to compensate the other for any loss suffered. Essential element of the contract of indemnity. There are two parties. The indemnity who promises to compensate, the indemnity who is protected against a loss. There are two elements, that is promiser and loss. Third, that is must be caused. The loss should arise due to the conduct of the promiser or another person. Legal contract. It must fulfill all essential of the valid contract, offer, acceptance, consideration, pre-consent, lawful object, etc. Express or implied. The contract may be express or implied by to conduct or circumstances. Example, a contract to indemnity B against the consequences of any proceeding which C may take against B for a certain sum of money. This is a contract of indemnity. Difference between contract of indemnity and contract of guarantee. Basis, contract of indemnity, contract of guarantee. Definition. Contract of indemnity, it is a promise to compensate for loss. Contract of guarantee, promise to discharge liability of a third person in case of a default. Number of parties. There are two parties, indemnity and indemnified. Three parties, creator, principal, debitor and summurator. Number of contract. Only one contract between the indemnity and indemnified. Three contract between creditor, debitor, between surety and creditor. Third, implied contract between servitor and debitor. Purpose: to protect from the loss, to assure us performance of the promiser or payment of the debt. Liability: primary and independent liability of indemnity. Second liability. Example, a promiser to indemnity B against the loss caused by the C. A guarantor guarantees or to C that B will pay. In short, every contractor of guarantee involves a third party and secondary liability, while a contract of indemnity involves the two parties and primary liability. Write a short note on what are the rights of finder of goods. Rights of finders of goods. Under the Indian Contract Act 1872, a finder of goods is a person who lawfully finds the good belonging to the another and takes them into his custody. Legally, he has the same responsibility as the Bailey Section 71. Right of the finder of the goods. Right to retain the goods. The finder can keep possession of the goods until he receives lawful charges or expenses incurred in preserving or finding the true owner. Example, if A finds B's dog and spend money on the food and care, A can retain the dogs until B reimburses him. Right to recover the expenses. The finder is entitled to recover from the true owner the expenses incurred for preserving the goods or finding the owner. Right to sue for reward it offered. If the owner has announced the reward for returning the lost goods, the finder can claim that reward upon returning the goods. Example, if B offers 5,000 rupees for finding the lost watch, A finds the find and return, A can legally claim two rewards. Right to sell the goods in certain circumstances only. The finder may sell the goods if the owner can be found after reasonable search or the owner refuses to pay lawful charges and the goods are perishable or the lawful charges amount to be 2/3 of the value of the goods. Example, A find the perishable fruit and cannot locate the owner. He may sell them before they spoiled. In short, write description, retain good until the lawful charges, recover expenses from the true owners, claim rewards it announced, sell goods in special cases, perishable goods, high expenses, owner not found, refuses payment. Summary, we can say that a finder of the good, like a bailee, he must take responsible care of the good and try to find the owner, but the law also protects his right to recover expenses, retain or even sell goods under specific condition. Thank you for watching video. LLB 3 years. Same first viva question. Subject law of tort. Paper number 3. Long broad answer question. Write a detailed note on justification in the law of torts. Answer. Justification of the law of tort. The meaning of the justification of the law of tort. In the law of tort, a justification refers to a lawful excuse or defense that allow a person to avoid liability for an act that would otherwise be considered a tort. In other words, even in an act causes harm, defendant can avoid responsibility if they prove it was legally justified. Purpose of justification: to protect a certain lawful act done in good faith or under authority, to ensure that liability arises for wrongful acts, not those that law permits or excuse, to balance individuals' right with public interest. Main justification: defenses of law. Quality non-fit injuria consent means to one who consent, no harm is done. If a person voluntarily agrees to suffer harm, they cannot later complain of it. Example: a spectator injured during the boxing match cannot shear the boxes he consented to the ordinary risk to the sports. Essential conditions: the consent must be free and informed. The act must be within the scope of consent. Inevitable accident: when an injury occurred without the negligence and could not have been avoided even with a reasonable care. Example: a driver suffers a sudden heart attack and loses control of the car, injuring the pedestrian. The act may be excused as an inevitable accident. Act as a God. Phase measure refers a natural forces so expected and irresistible that human foresight and prudence cannot prevent the damages. Example: floods, lightning and earthquake, etc. Railway company is not liable for loss of good destroyed by unforeseeable floods. Essentials: the act must be due to the natural causes. It must be unavoidable even with a reasonable care. Fourth one, private defense, self-defense. That is, every person has a right to protect with person or property against unlawful aggressions. Conditions: the force must be reasonable and proportionate to the threat. It must be used only to repeat the immediate danger, not to take revenge. Example: if someone attacks A and A hits back, self-defense causing the minority injury. A is not liable. Necessity: an act done to prevent the greater harm is justified even though it causes the some damages. Example: a doctor performs emergency surgery without consent to save a life, destroying property to prevent the spread of fire. Statutory authority: it an expressly or implicitly authorized by the law. It is not actionable even if it causes harms. Example: noise and inconvenience caused by the construction of a railway under a statutory authority can be a ground for noisiness. Conditions: the act must be done strictly within the legal limit, and negligence in exercising the authority can still make the person liable. Plaintiff, the wrongdoer. The plaintiff himself involves an unlawful act controlled by the harm. It may be a detained relief. Example: trespasser injured by owners. Mild defense acts cannot sue for the damages. Summary tables. Justification, meaning, defense. Example: violation, non-fit injury, consent to suffer harm, specter at the game injured, infected accident, unavoidable accident, despite care, sudden mechanical failure. Act of God, natural, unforeseeable event, earthquake damages. Private defenses protect or person property, hitting attack in self-defense. Necessity preventing the greater harm, breaking a window to save a child. Statutory authority act the permitted by the law of noise, railway constructions, plaintiff the wrongdoers, plaintiff own fault, trespasser injured by the owner. Conclusion. Justification in the tort law acts as a legal shield that protect involved individuals from the liability for actions that are not truly wrongful. They ensure that the law torts punished fault and negligence, not honest and reasonable conduct performed under the lawful or unavoidable circumstances. Write a short note on absolute liability. Absolute liability short note. Absolute liability is a legal principle under the law of tort that holds the person entity strictly responsible for a harm caused by their actions or activities, regardless of intent, negligence, or fault. This means that even if the defendant took all the possible precautions to prevent the harm, they are still liable for the damage caused. The concept was established in India in the landmark caused by MC Mehra versus Union of India in 1987, commonly known as the oleum gas leak case. The Supreme Court evolved this rule and addressed the modern industrial hazards, holding that enterprises engaged in hazardous or inherently dangerous activities have an absolute and non-delegible duty to ensure the under the absolute liability. No exceptions or defenses like act of God or third party fault are allowed. The liable party must compensate the victim fully for the harm caused. These rules ensures the greater protection to the public and promotes the accountability among the industrial and handling dangerous substances. Thank you for watching.
Paper number 4 BNS Bharatiya Nyay Sanhita. Long answer. Question. Define rape. Explain ingredient and resumptions of the concept of the rape with relevant case laws. Let us see the answer. First of all, see what is the definition of rape. Under Indian law, Section 375, Penal Code, IPC 1860. Rape is defined under the Section 375, the Indian Penal Code, IPC, as a sexual act by a man with a woman under circumstances falling within any of the 7 descriptions or laid down in the sections. After the Criminal Law Amendment Act 2013, the scope of offense was widened significantly. According to Section 375, a man commits the rape if he penetrates his penis to any extent into the vagina, mouth, uterus, or anus of a woman or makes her do so with him or any other person, or insert any object or any part of the body other than the penis into the vagina, uterus, anus of a woman, or manipulates any part of her body so as to cause penetrations, or applies his mouth, vagina, anus, or uterus, urethra of a woman. Under any of the following circumstances, against her will, without her consult, with her consent, with obtained by putting her or any person in whom she is interested in fear of death or hurt. Under any of the following circumstances, against her will, without her consent, with her consent when obtained by putting her or any person in whom she is interested in fear of death or hurt, with her consent when the man knows he is not her husband and her consent is given because she believes he is her husband. With her consent when at the time of giving consent she is unable to understand the nature of the consequences of that consent due to the unsoundness of mind or intoxications. When she is under 18 years of age without consent. When she is unable to communicate consent. Essential gradients of rape. To establish offense of rape, the following ingredients must be proved. First one, penetration. Even the slightest penetration is sufficient to constitute rape. Complete intercourse is not required. Case law. State UP versus Choti Lal 2011. Section 550. Slightest penetration is sufficient to prove case. Against the will or without consent of the woman. Against her will means that act was done in spite of resistance. Without her consent means that she did not agree to the act voluntarily. Case law. Tukaram versus State of Maharashtra 1979. SSC 143 Mathura case. Consent obtained under fear or coercion is not valid. Consent obtained under the misconception or coercion is not valid. Consent must be free, voluntary, and informed. Case law. Kaini Rajan versus State of Kerala 2013 SS case, Supreme Court case 130. Consent must involve the active will of the woman in participating in the sexual act.
victim under 18 years of age. Consent is irrelevant in the victim in the below 18 years. Case law, State of HP versus Srikant Shekari 2004 at SSC 153. Consent of the minor age is immaterial. Prescriptions regarding the rape. Under the Indian Evidence Act 1872 section L 114A, presumptions of absence of consent. In a prosecutions of rape under the certain circumstances such as custodial rape of or when consent is in question, it is victim state in the state evidence that she did not consent with the court shall preserve that she is not a consent. This is mandatory presumptions. Case law, State of Punjab versus Gurmeet Singh 1996 to SSC 384. Testimony of the prosecutors is sufficient for convictions if found credible. Corroboration not necessary. Section 53A, evidence of the character or past sexual evidence relevant. The past sexual history of the victim cannot be used to prove consent or questions her credibility. The two-finger test or questions about past conduct her impermissible. Case law, State of Jharkhand versus Shailendra Kumar Rai at Pandav Rai 2022. Reformed that past sexual history is irrelevant. Important judicial interpretations. Tukaram versus State of Maharashtra, rape case 1979, highlighting the need for consent to be real and voluntary leads to be in 1983 amendment in rape law. Buddhistava Gautam versus Shubhra Chakraborty 1996 SSC 490 recognized the rape as a voluntary of the fundamental human right and dignity of the woman. State of Punjab versus Gurmeet Singh 1996 assumed that the victim testimony alone, if trustworthy, is enough to convict the accused. Leela at Rajiv State of Hyderabad 2013-14 SSC 643. The two-finger test was declared unconstitutional as it violates the dignity and privacy of the woman. Conclusion: rape is a heinous offense and a grave violence of the woman's bodily integrity and dignity. The law focuses on the consent as the core determinant any sexual act without free and voluntary consent constitutes rape. Indian courts have evolved a victim centric approach, ensuring that the testimony of the prosecutrix is treated with due respect and not subjected to unnecessary suspicion or humiliation. Question number 2. Write a short note on right of private defense. Right of private defense. The right of private defense is a legal right that allows a person to protect themselves, other, or their property from unlawful harm. The right is recognized under the section 96 to 106 of an Indian Penal Code IPC. It permits individual to use reasonable force to defend against an attack or threat when immediate help from the public authorities is not available. However, this right has limitations. It cannot be used to inflict more harm than necessary, and it ends when the threat ceases. In short, the right of private defense ensures that a person is not punished for acting in self-defense while protecting life, liberty, property against unlawful aggressions.
Q. 1. Right about citizenship under Article 5 to 11 of Indian Constitution. Ans. Sure. Here's a clear and concise explanation of citizenship under Articles 5 to 11 of the Indian Constitution. Down finger. Citizenship under Articles 5 to 11 of the Indian Constitution. The Constitution of India, under Part 2, Articles 5 to 11, deals with the concept of citizenship at the time of the commencement of the Constitution, i.e., the 26th of January 1950. These provisions determine who were the citizens of India when the Constitution came into force and empower Parliament to make laws regarding future citizenship. Article 5 Citizenship at the commencement of the Constitution. Article 5 defines who became a citizen of India on the 26th of January 1950. A person was considered a citizen of India if she 1. Had domicile in India, and 2. fulfilled any one of the following conditions. Was born in India, or either of whose parents was born in India, or had been ordinarily resident in India for at least 5 years immediately before the commencement of the Constitution. Article 6 Rights of citizenship of certain persons who have migrated from Pakistan to India. This article deals with people who migrated from Pakistan to India before or after the 19th of July 1948 due to partition. Those who migrated before the 19th of July 1948 were deemed citizens if they or their parents, grandparents were born in India and they were ordinarily resident in India since migration. Those who migrated after the 19th of July 1948 had to register as citizens with a government officer appointed for the purpose after residing in India for at least 6 months before applying for registration. Article 7 Rights of citizenship of certain migrants to Pakistan. This article deals with persons who migrated from India to Pakistan after the 1st of March 1947. Generally, such persons were not considered citizens of India. However, If they later returned to India under a permit for resettlement or permanent return, they could become citizens again if they fulfilled the conditions of Article 6. Article 8 Rights of citizenship of certain persons of Indian origin residing outside India. This article covers persons of Indian origin who were residing outside India, in countries like the UK, South Africa, etc. At the time of commencement of the Constitution, such persons were entitled to register as citizens of India at the Indian consulate in the country of their residence, if they or their parents, grandparents were born in India. Article 9 Persons voluntarily acquiring citizenship of a foreign state not to be citizens. This article states that any person who has voluntarily acquired citizenship of another country is no longer a citizen of India. This means India does not allow dual citizenship in the constitutional sense. Article 10 Continuance of the rights of citizenship. Article 10 ensures that every person who is or is deemed to be a citizen of India under these articles shall continue to be a citizen, subject to any law made by Parliament. Article 11 Parliament to regulate the right of citizenship by law. Article 11 gives Parliament the power to make laws regarding the acquisition and termination of citizenship and all other related matters. Under this provision, Parliament enacted the Citizenship Act, 1955, which governs citizenship by birth, descent, registration, naturalization, and incorporation of territory. Summary table. Article Subject Matter Key Point. 5 Citizenship at commencement domicile plus birth, descent, residence. 6 Migration from Pakistan to India before, after the 19th of July 1948 rules. 7 Migration from India to Pakistan not citizens unless they return under permit. 8 Persons of Indian origin abroad entitled to register as citizens. 9 Voluntary foreign citizenship loses Indian citizenship. 10 Continuance of rights until Parliament provides otherwise. 11 Parliamentary power. Parliament can make citizenship laws. Q. 2 Write a short note on preamble of Indian Constitution. ANS. Short note on the preamble of the Indian Constitution. The preamble is an introductory statement that outlines the guiding principles, philosophy, and objectives of the Indian Constitution. It serves as the key to the minds of the framers and reflects the ideals that inspired the nation's independence struggle. The preamble declares India to be a sovereign, socialist, secular, and democratic republic. It aims to secure for all citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and fraternity, assuring the dignity of the individual and the unity and integrity of the nation. Originally adopted on the 26th of November 1949, the preamble came into effect on the 26th of January 1950. The 42nd Amendment, 1976 added the words, socialist, secular, and integrity. Quote, in essence, the preamble embodies the spirit of the Constitution and acts as its philosophical foundation.